me last night. I did a show with Reluctant Prophet about, I realized that I made a couple of errors with respect to some of the things that I talked about, so I'll just correct one of them. There wasn't an admission by the prosecutor that a speedy trial had been denied. I recognized that this morning as I was sort of waking up. But the admission is that there was no request to continue the trial. And my argument was that because allegedly, and again, I'm not an Arizona attorney, that because of that and because of a 20-day discovery rule, that in order, it was already past the ability for Lane to do the 20 days discovery, that the case should have been dismissed by the judge. And ultimately, the case did get thrown out. But as usual, the way a lot of courts do it, they try not to dismiss the cases on the merits of what especially pro se litigants argue, and they try to dismiss them based upon some other argument. And that's really unfortunate, but that is the system that we live in. So anyways, now that is corrected. Hey, what's going on? What's the matter, you? Writ of Matt Demon? I don't know what that is, brother. What's going on? Let's OTVO. Cops are 5150. Jody Shiloh. So I'm doing a quick walk. As you guys know, my back has been jacked up, so I haven't been able to train with weights, but I do have my Second Amendment shirt on. Hopefully you guys like that, because today we're talking about the Second Amendment. And I know there's a little bit of a drop zone where we're at, but hopefully we can have some fun. So this has to do with the Kansas Morgan machine gun case decision that's now being contested by the Trump administration. Now, originally, Pam Bondi had some Obama leftist Biden holdover attorneys handling this case, and they failed to make pretty much any argument that they should have made that would have protected the Second Amendment. And so this sort of ties into what's the matter you's argument that the parties are all the same. Now, a machine gun is simply a firearm, in many cases, that is a crew-served weapon. And because of that, it wouldn't typically be an arm that was normally in common use at the time of the Second Amendment, according to at least some dicta in Heller and a couple of other decisions, which we'll get into. But my position is that all a machine gun is it could be an M16, it could be an AR-15, or even a Glock, where you push the trigger down and it fires more than one round at each squeeze. So in essence, that's really what a machine gun is. It doesn't necessarily have to be a crew-served weapon. It's a fully automatic weapon. And of course, arguments that the Democrats have made for years is that a machine gun is an offensive weapon. Well, I know that that's not true because I was a Marine. And I know that Marines are an offensive fighting force. But what do? We're an offensive fighting force in order to defend our way of life. And a machine gun can be used offensively or defensively. And what it's designed for is to suppress, so we can either make bounding retreats, bounding, well, I don't want to say retreat because I'm a Marine, but basically a fighting withdrawal, right? By suppressing incoming fire. That's really what a machine gun is for, is to suppress incoming fire. If I'm taking fire from a position, I can put thousands of rounds on that target to suppress that position from firing at me. So my team can make maneuvers to either take that target out laterally or to make a bounding withdrawal. That's all it really is. So in that regard, I disagree with the premise that a machine gun is 100% an offensive weapon. And just like I believe that you should be able to have maximum amount of firepower in your handgun or your home defense rifle, I also believe that it shouldn't be a problem to have a machine gun. And we know that people legally possess machine guns if they pay a shitload of money to buy a federal firearms permit to allow them to have one. Hey, let's OTVO. So in this case, the Kansas City Morgan decision, which is now being contested by Trump, but which had not. So here's what happened. This case went up, I think it was the 10th Circuit, to a lower court, and the judge simply found, based upon the recent Supreme Court precedent Hold on, I'll just get into. Well, based upon, and I'll get into you in a minute. I took some notes, but I'm walking. Based upon Supreme Court precedent, that the 10th Circuit found that historically there's nothing preventing you from owning a machine gun, because sure, you're entitled to have a firearm that wasn't in common use at the time of the Second Amendment, right? I mean, obviously they had muskets, they didn't have semi-automatic. Well, they did actually, but we'll get into that in another time. Primarily it was muskets and things like that. So, but then there were some other cases that came down, which we'll get into. But the bottom line is that it was found by this 10th Circuit judge that there was nothing preventing this man who owned, I believe it was a Glock with a Glock switch and what's a fully automatic rifle. There was nothing preventing him from having that. And because of that, his case was reversed. And then it went up on appeal. And then ultimately it went to the U.S. Supreme Court. And now that's where it's sitting. Now the problem is that the government didn't make a lot of arguments that they were supposed to make in the lower court. And for whatever reason, then they started making them. And Bondi put these basically lefty DOJ officials in charge, which is why we're having some of these issues right now. Good morning. And one of the issues is they're trying to introduce new evidence on appeal. And so I talked about this the other day with you with respect to doing writs. Talked about a writ of coram nobis, which is basically but typically with a writ of coram nobis, you argue that you've discovered new evidence and that would entitle you to reverse something. And typically that's only going to be made by a defendant, not the government. But in this case, the Trump administration is now trying to argue, well, we didn't make all these arguments and we let this case slip through. So now we want to have a second bite at the apple. And we want to be able to say that machine guns are inherently dangerous and that they're dangerous and unusual. So before I really get into, and that case is called U.S. versus Morgan, and the Trump administration launched a very disconcerting anti-Second Amendment argument at the 10th Circuit Court of Appeals. And I mean, it's just unbelievable to me. And this is a case again where a judge in Kansas found that machine gun possession charges are unconstitutional and they violate the Second Amendment. So hopefully you guys are following that. I got a bunch of notes. Just give me a second here. This is kind of blowing my mind. I mean, this is just so over the top. It's just crazy. All right. By the way, good morning, everybody. Good morning, Pro Se America. Good morning, what's the matter you? All right. So, and they're saying they're saying it's totally okay. The lower court says it's totally okay to have a machine gun, which I believe it is. It's protected. Your government's certainly not going to protect you, right? They never do. So anyways, the Kansas Morgan decision is now being contested by the Trump administration in the 10th Circuit. And the Trump DOJ is now arguing that the case should be reversed, that machine guns were not in common use for lawful purposes at the time of the founding of the Second Amendment, and that makes them dangerous and unusual. So basically what they're doing is they're turning basically all the cases since Heller and arguing they don't apply to this case. And so that's very disconcerting to me, because this is worse than something that you would hear from a Democrat president. So you guys should definitely be reaching out to your congressmen and senators and complaining about this one, because you know that there are several leftist judges at the Supreme Court that would love to get their hands on this case. And so let's get into what dangerous and unusual really means, because Democrat judges, for the most part, don't seem to know what it means, or maybe they do, and they just want to use the modern definition of what dangerous and unusual means to get what they want. All dangerous and unusual means it is a common law restriction on the time, place, and manner in which you can display or carry a firearm. And so I've given examples in the past, but I'll give you another one. A fully armored knight galloping through a shopping center with his lance and his sword, all right? That would be considered dangerous and unusual because it's an unreasonable time and place with which to carry. And so a time, place, and manner restriction could be placed upon that particular activity because it might freak out some woman who's pushing a stroller through the mall. Hopefully that makes sense, guys. It might just freak someone out. And so because of that, it has been found by the historically to be a reasonable time, place, and manner restriction. So all dangerous and unusual meant was the activity, not the weapon. But modern day, especially Democrat judges, will say, no, what it really means is that the weapon itself is dangerous and unusual, and they're never able to actually pinpoint what that means. Case in point would be trying to say an AR-15 is dangerous and unusual because it's a semi-automatic. Well, 90% of commonly used rifles and handguns are semi-automatic. So what the left courts, the Democrat courts, do is they say, well, an AR-15 looks like a dangerous weapon because it's black. Kind of racist, right? Because it has a bayonet lug and because it has a flash hider. And because of that, that makes it dangerous and unusual. And that literally is the Democrat Party's argument as to why AR-15s should be banned. And they always say, well, we don't want to ban semi-autos, we just want to ban AR-15s, which we all know is a lie. Because in Colorado, they're already trying to ban every single freaking semi-automatic rifle on God's green earth. So, anyways, that's the argument. Now, Trump is basically using Barack Obama, Joe Biden arguments for the proposition that machine guns were not in common use for lawful purposes at the founding of the Constitution, and therefore they're dangerous and unusual, and they should be restricted by the federal government, essentially however the government wants to restrict them. And we know that for hundreds of years, at least 70 or 80 years, people could obtain a machine gun by going to the gun store. I think you could even get them through the Sears catalog, if I'm not mistaken. So we know that they were, in fact, in common use at some point in American history. And that's why, in part, that's why we won. And when I say we won, the American people won originally at the lower federal court level. And so, in essence, they're trying to compare it to short-barreled rifle cases, all right? So, short-barreled rifle would just be like a shotgun that's like a sawed-off, for example, where you had to get a tax stamp and get permission from some lefty over at the courthouse. Here, what I'm going to do, guys, is I'm going to sit down and go through my notes really quick, and then I'll get back onto my walking. And Wes, I haven't looked at your comments, but I'm sure you've got a ton for me. And I'm not going to say I'm going to eat crow, but look, I never trusted either party, and I never have. So we'll get. I already know you're going to have a bunch for me. So, anyways, really quick, let's get into this. Hey, cool, we got some birds going on over here. So really quickly, they're trying to say that this is no different than a short barrel rifle or a suppressor case currently making their way through the court system. And the Trump administration now has submitted a new brief, and it shows that Pam Bondi basically isn't doing what we hired her for, at least from our perspective as libertarians and people who believe in the God-granted right to keep and bear and possess firearms to defend our families and common defense against government abuses, right? Because we know that the primary purpose of the Second Amendment, contrary to what most Democrats think, was not for hunting. It was to defend ourselves against oppressive government, because the King of England had tried to seize our powder houses, which was our gunpowder. And that's really what sparked off the war, and that's what they don't teach you in the public school system, which is why we homeschool our kids, so we can teach them the true history of this country. Give me a bunch of ones if you agree. Good seeing you, SWE Observer. All right, so let's get into it. So Pam Bondi basically has failed here. Now, Tamori Morgan was charged with 2 counts of possessing a machine gun. He was accused of basically not abiding by 18 U.S.C. Section 922. He was charged with possessing a machine gun, an Anderson gun, and then a machine gun conversion device for his Glock. Like I said, a Glock switch, right? And so those items were found in his possession, and because of that, he was convicted of violating a federal law. But in response, he moved to dismiss it, saying that this violates the Second Amendment, according to Heller and a whole other line of cases, right? And so as a result of that, the court found that the government failed in their mission of proving that he couldn't have these machine guns, he couldn't have fully automatic firearms, which, you know, he was right. The lower court is right. That is correct. That historically, he's completely right. So now the government's come along and they're saying that Heller says that machine guns aren't allowed, and that's not what Heller says. Heller was not it was not a machine gun case, first of all, and so it was purely dicta, and so because of that they lost. And now Bondi is raising the Heller argument, saying that no, Heller really means you can't have a machine gun, and so the government's interpretation basically is opposite of what Heller really stands for, and that's the problem. If this goes through, basically Heller is going to be overturned. That the spirit of Heller will be done. So just keep that. Just mark my words, okay? Mark my words. This will be the end of the Second Amendment. It will be done by a Republican president, by Pam Bondi, who we know is not pro-Second Amendment. As far as I'm concerned, she's a deep stater. I don't know how she got appointed to this position, but I kind of do know how, because the deep state does not want we the people to be able to possess commonly used firearms, especially machine guns. Why? Well, I think we know why. So in any event, the Second Amendment applies to arms, according to Heller, that did not exist at the founding of our country. Okay, that's what Heller talks about. And so basically now Trump is arguing what Obama and Biden argued, which is that no, it only means you can have muskets. That's essentially the Democrat Party's argument, that the Second Amendment really only applies to muskets. But they don't use the same arguments when it comes to the First Amendment, you know, that you shouldn't be able to have a typewriter, right? So in essence, we have the Miller decision now is another case that talks about machine gun restrictions, which I'm very familiar with. And so they're going to argue that Miller says that you can't have machine guns, but that's not what the Miller case stands for either. It talks about service in the militia, but it went on to say that, you know, the Miller question is different than those being reviewed in this particular case, because the Miller case dealt with short-barreled rifles, and this case is a machine gun case. So again, you know, they're just arguing cases that aren't on point for anything they can grasp at to make sure that we the people can't own a machine gun. And who wouldn't want to be able to have a machine gun? Look, I'd love to have a machine gun. The problem is I don't feel like paying for a federal firearms permit, right? You can get one if you can afford the permit, which is outrageously expensive. So, and then as far as the way you can carry it in your car and stuff, it's like the problem with the gun laws in this country, especially because of Obama's justices that he put into power, is everyone's in violation of a gun law, no matter how law-abiding you are. That's just the way it is. So basically, Miller is unpersuasive because it didn't deal with the same items that the federal government, the federal court reviewed. And so because of that, again, I was trying to tell you that the government is now trying to argue new cases that they didn't argue at the lower court. So think about that. How is it that we can't argue new evidence on appeal, but the government can when they lose so badly, right? So that's kind of what's going on here. So basically, the judge found that the 2 analogs put forth by the Biden administration didn't justify the charges for possession of a machine gun. And then the judge also talked about how the government has not met its burden, and this is the lower court, by the way. And looking at historical analogs, regulation of weapons at issue were consistent with the nation's firearm regulations that you can have a machine gun. The government barely tried to do anything, and the Supreme Court has indicated that the Bruin decision says that the Bruin decision that talks about historical use of firearms it applies to this case, to being able to have a machine gun. I mean, you guys have seen movies where there's that one Second Amendment movie where the dude goes into court and he, not court, but he goes into a gun store and he picks up a Browning automatic rifle, the one with Kevin Costner. You guys have seen that one? So anyways, you could just walk into a gun store and get yourself a BAR or a Thompson submachine gun. No big deal, no big deal. So in any event, the federal district court level, at the federal district court level, the government has now appealed it to the 10th Circuit. And right now, the Trump administration, now they're putting forth this new brief again, saying that the lower court decision should be reversed, that the Second Amendment does not apply when it comes to Mr. Morgan and these types of items because they're not protected. And so he filed his response, Mr. Morgan filed his response, and he is saying that that the government's trying to pull a fast one, that the Trump administration and the anti-Second Amendment, Pam Bondi, and I agree, she's definitely anti-Second Amendment. Make no mistake about it. Donald Trump is a traditional Democrat. He's a traditional blue dog Democrat. He always has been. He's a tax and spend Democrat, and I've always told you guys that. He's not a conservative Republican. He's definitely not a constitutionalist. So let's just leave it at that. So in any event, let's get into it. So he basically points out that the federal government is trying to make new arguments on appeal, which we know, if you followed my channel, you're not allowed to make new arguments on appeal as a general proposition. This is really disconcerting to me. And he talks about some historical analogs and other things that the government is trying to bring in front of the Ninth Circuit that they did not bring in the original case. Now, instead, in front of the district court, the government only put forward 2 historical arguments, okay? Only put forward 2. And he's saying that the 10th Circuit should reject anything that's new. And the lower court the government's saying that the lower court was in error. And so that's kind of where this case is going. And unfortunately, there's a bunch of like Biden and Obama holdover attorneys that were on this case originally, and it looks like Bondi's going to let them take charge of this case again. So essentially, you'll have some leftist, Marxist, Democrat prosecutors more than likely arguing this case. So there you go. Just like I said, many, like, what's the matter, you would say, 2 heads of the same snake. So in essence, what's going on here is the United States attorneys have been assigned by President Trump, and they're basically, originally they failed to properly address issues of the case to stop the anti-Second Amendment arguments from proceeding. So that's what happened is, so the case was able to go up on appeal because some Obama, Biden appointees didn't make a bunch of arguments that they should have made to basically railroad this and get it up to the Supreme Court. And so there was like a big problem where they're like, we gotta suspend these guys. So they basically put these guys on timeout, like suspended without pay, right? And now essentially they're going to go back and make even worse arguments. So we'll get into that in another show, but this is really crazy. So because they basically properly failed to review issues, these guys were basically kicked off the case. But now they're going to come back and make even dumber arguments. And they argue that machine guns were not in common use for lawful purposes. And because of this, the 10th Circuit's review is not limited to just the historical statutes provided by the federal government at the lower court, but they are now allowed to bring in new pieces of evidence, which we know is not allowed. It's improper. And so it makes AG Bondi look horrible. It really does. Well, it makes her look like what we always knew she was, which is an anti-Second Amendment, pro-big government, basically blue dog Democrat, just like Donald Trump. So anyways, her office has now found that basically machine guns are not protected by the Second Amendment, and that Heller authoritatively says that, which it doesn't. Heller has nothing to do with machine guns. There was a small comment in dicta about machine guns. So in any event, she's saying that it doesn't protect law-abiding citizens from having a machine gun, which is crazy because based upon our original Constitution, we're not even supposed to have a standing army for longer than 2 years. And that's why every 2 years, the U.S. Army has to go through a Senate appropriations bill to get refunded, because we, the people, are supposed to be the ones who defend our country from all enemies, foreign and domestic, not a standing army. Just like the Romans, our founding fathers were terrified of a standing army. And why is that? Well, look what happened during the Revolution, and you'll know why. Because all it takes is a couple of pro-royalist type people, like an Obama type, big government, centralized control type, and then you lose your right to keep and bear arms basically overnight. So in any event, what they're saying here is that they're saying that the limitation for machine guns is fairly supported by the prohibition of carrying dangerous and unusual weapons. And again, I've told you, dangerous and unusual weapons never had anything to do with the weapon. It had to do with the time, place, and manner in which you carry the weapon. Like carrying a machine gun through a shopping mall would be considered a dangerous and unusual practice, so the government could then pass a restriction on the time, place, and manner where you can carry the weapon. It never had anything to do with the weapon itself, and that's why I have a problem with modern Marxist judges, because they completely just make up stuff that doesn't, it's not even true, to cover their political ideology, because they're terrified of guns, because they've gone to public schools and the safe space university system, and they're mirroring and matching what goes on in Germany and the UK, not our historical roots as Americans, which is totally different. We protect people's rights. We don't steal them like those other countries do. So they go on to state that the Morgan case wrongfully focuses on whether guns are arms, although machine guns are weapons of offense. And so they say that they're weapons of offense and they're not protected. Of course, I say they're not necessarily weapons of offense. Machine guns can be used for defensive and offensive purposes, just like any other firearm. You can't classify them as something different than any other gun. It's just that machine guns can provide suppressing fire, which gives you the ability to fire and maneuver away from or onto a position. Okay, and that's just traditional military training, right? So now the Trump administration is basically, and all of the underlings in Pam Bondi's office are arguing that machine guns are not protected arms. They state that Heller makes clear that the Second Amendment only applies to certain types of weapons, which is absurd. What the Second Amendment really stands for is that that Heller stands for is that citizens can have what's called bearable arms. In other words, the standard infantry arm that an infantryman could possess, which would also include an M16. And guess what? M16s can fire 3-round burst or full auto. So what Heller really stands for is that, yes, you could have a machine gun, but that's not what the Trump administration is arguing. So, and they're going into the short-barreled rifle, short-barreled shotgun arguments. They're saying that you have to have a tax stamp to have one of those. And we know that they don't like short-barreled rifles and shotguns because they're easier to conceal in your car, which to me is a great thing, because if a criminal or someone breaks into your car, it makes it harder for them to find it. So I just don't understand the government's arguments there. But in any event, they're arguing that machine guns aren't protected, just like short-barreled shotguns aren't protected. And they're saying that suppressors aren't protected. And if you guys have seen the old movies like the A-Team where they put a suppressor, it makes a noise that you can barely hear. That's not what suppressors do. You can definitely hear suppressors. The idea behind a suppressor is so you don't have to wear ear protection. And so in Marine units, especially MARSOC and Force Reconnaissance, and in Special Operations units, they use suppressors not so your enemy can't hear you, but so you can hear other people making commands and talking to you without blowing your eardrums out. And I know from having major hearing loss from the Marine Corps, look, they told us to wear ear protection with a wink and a nod, but we didn't, right? We didn't, because you couldn't hear people making commands in the field. So had we had suppressors when I was in, I would still be able to hear and not talk so loud that my wife tells me to be quiet when we're at restaurants. And any of you veterans understand how that works. So obviously, what's going on, Cannon? The idea behind a suppressor is that it keeps it silent enough to where you don't blow your eardrums out and you can hear commands of people. So that's another nonsense argument that these fools have made. These leftist prosecutors who are now working for Donald Trump, which we kind of all knew this was going to happen, right? So at the end of the day, they're basically trying to compare a machine gun to a suppressor to a short-barreled rifle, saying that people aren't allowed to have them because they're dangerous and unusual, even though common law, dangerous and unusual, has nothing to do with the weapon. It has to do with the time, place, and manner in which the weapon can be carried. And that's the true common law precedent. All right, so this doesn't look good for Trump. It doesn't look good for Bondi. Guys like me and my friend Dick Heller were really looking forward to having a pro-Second Amendment president. And we can clearly see that that's not going to happen. So let's take another look here. They're basically saying the machine guns are not typically possessed by law-abiding citizens for lawful purposes, which is complete nonsense, especially when they flood our country with illegal alien criminals from Venezuela. I think that being able to have a machine gun would be a very proper thing, knowing that we've had wide open borders with over 20 million illegal alien criminals that our government let in here, having their way with our women, with our children, people from Haiti flooding in to our cities in Ohio, right? Immediately getting driver's license and causing mayhem on the streets, being abusive and physically attacking people on buses, having no respect for our Constitution or our way of life, refusing to adapt to our culture and instead trying to force their culture on us. Absolutely not. Absolutely, you should be able to have a machine gun or any other kind of weapon you want to defend your family. Give me a bunch of ones if you agree. Now, basically, they go on to argue in their opening brief that machine guns were not typically possessed for lawful purposes and are instead dangerous and unusual. And they're saying that Morgan's responses can't be overcome, and therefore the DOJ is allowed to come up with these new arguments on appeal. They're saying they're definitely not protected, and so basically that there's a disconnect here, in my opinion, between Bondi and Trump and the whole purpose why we put her into office. And the bottom line is now it's probably going to go to the Supreme Court, and because of that, Kash Patel and Pam Bondi better make a clear stance on what they're talking about, because to me it sounds like everything that we were fighting for to make sure we could have a pro-Second Amendment president, this will be the unwinding, the unraveling of the Second Amendment under a Republican president if this goes through. So obviously it looks like the Trump administration's not pro-Second Amendment, like many of you, like Wasamata, you said. And so that's kind of like where we're at. And so because of that, let me see here. There's obviously we don't want these anti-Second Amendment arguments to proceed, obviously. But now the Trump administration is pushing for that. And let me see here. At the end of the day, look, I'll keep you updated on any developments that come up. But that's pretty much all I have to say about that. So what we'll do now is I'll try to do Q&A as I walk back to the crib. You know what I'm saying? So what do you guys think, man? You think I nailed it? Give me a bunch of ones if you think I nailed it. Hey, Dick Smith, good seeing you. And let's see here what we got here. We got Pro, Say, America, DLZ. All right, man, love it. Good seeing you guys. Now, there's also another one. I believe it's the Duncan versus Bondi case. So that has to do with the California, what we call standard capacity magazine ban that the Democrats have been trying to push on us for years. And we thought we'd really hit a home run in that case, where we had a pro-Second Amendment Republican judge in San Diego find that these magazine bans were unconstitutional. And so let me just frame it for you. Democrats call standard capacity magazines that were designed and commonly used with firearms, they're trying to say that it's really just an accessory. A magazine is an accessory and it's not a functional part of the weapon. And that they should be able to decide how many rounds or bullets that you can shoot out of your gun at any given time. And so they came up with this arbitrary and capricious number of 10, which we know they'll limit to 1 like they did in the UK, then ultimately force you to convert your AR-15 into a bolt weapon. So they basically made people in the UK put a basically a bolt, a manual bolt operating system to get rid of the gas operating system and make them non-semi-automatic. And this is exactly what they want to do. They're basically just, the U.S. Democrats are trying to make the Second Amendment a mirror image of what's in the UK or Australia, where people basically essentially don't have the right to keep and bear arms. And Canada ultimately is how California wants it to be, where you basically, if you have a gun, you can have it, but it has to be locked in your safe and you can never pull it out. So that's, in essence, what the left is trying to do in California and nationwide. I mean, if camel toe had gotten in, that would have been the end of the Second Amendment. But we see that now with Trump, very similar stuff going on. And so it's terrifying. And with this Bonta, this Duncan versus Bonta case, and Bonta being the Attorney General of California, a lower court judge said, no, this is ridiculous. It's not an accessory. It's an essential part of the firearm, a magazine. And if a magazine comes from the gun store or the manufacturer with 30 rounds, that's what it's supposed to have, is 30 rounds. And for some arbitrary and capricious lefty who spent their time at Berkeley to say, oh, that's dangerous, you shouldn't be able to have more than 10 rounds. Well, and they, of course, they never have any argument that is logical, is logic-based, that can support any of these positions. They just come up with these numbers, and it's all about safe spaces and being scared and not wanting people like you and I to be able to defend ourselves, essentially, in my opinion. So what's going on is, of course, that case went up to the Ninth Circuit. And the Ninth Circuit, of course, there's what, like one or two conservative justices. I think we had Van Dyke, who's a conservative, who said, well, it's absurd. I showed you a video where he goes in chambers and he strips down a weapon. He shows you what a magazine is. He dumps a bunch of weapons or mags on his desk. Really, really cool. But unfortunately, there's not very many conservative pro-Second Amendment justices. And why is that? Well, many say it's because of our so-called education system, where you have kids going to a far left rainbow flag mafia public school, and then from there they go into a far left university system. And so because of that, you have a skewed, very far left mindset, the groupthink mentality from these educational systems. And that's where your lawyers come from. And so because of that, you don't have very many lawyers who really understand or care about the historical underpinnings of America and what made us great, which primarily was the ability to defend yourself against overreaching government. That was the whole point. And so as a result, many people are disconcerted that these judges don't care about our founding fathers. They think our founding fathers were just a bunch of racists, bigots, and homophobes, because that's what they were taught on in public schools and on college campuses. And so it's very, very rare that you will have a conservative pro-Second Amendment judge to begin with. Give me a bunch of ones if you agree. And this is just what other people say. I'm not necessarily saying that, because obviously I have to be careful about things that I say, because I am an officer of the court. So what I would get into is that it went en banc, ultimately, the Duncan case, to the Ninth Circuit. And of course, en banc means full panel, which means far left judges. And they overturned the lower court on the magazines and said, no, the government has the right to restrict how many rounds you can have in your magazine. A magazine is just an accessory. And essentially what they're saying is that by this decision, that anything on your firearm, that your firearm is now illegal, because everything on a firearm is an accessory. And that's the problem. Every single piece of your firearm is an accessory based upon this decision. And so every time you have a somewhat decent pro-Second Amendment decision, you'll have a very far left justice or judge come up with a way to basically undermine that by coming up with what I consider to be extremely feckless arguments. And so in this case, a trigger is an accessory. So they could just decide tomorrow that triggers are dangerous and unusual and that we should ban triggers. Well, how is your weapon going to be effective? Now, what they say is, well, that's different. Magazines are different because, you could still have, a 10-round magazine, but who's to say they can't change that tomorrow and say you can only have a 1-round magazine? Who's to say they can't come up in a month or two when they get enough political power and say that you should even have a magazine. All mag wells should be blocked, and you can only load your round in through the top into the chamber that way. Who's to say they can't do that? Well, that's precisely what they want to do, and they're laying the framework to do that. That's precisely what the left wants to do, and unfortunately, it appears that's what the Trump administration is heading towards with these decisions. And this machine gun case is going to be probably, if it goes up to the Supreme Court, you're going to have probably Roberts, you're going to have the female justices all rule that this is perfectly okay. That's my prediction. The Obama, the leftist judges, as well as the New World Order judges and justices, they're probably going to rule that, no, we need to be more like the United Kingdom and Australia, and that we agree that what they call high-capacity magazines. Remember, framing is very important with the Marxists. They like to frame things by using words that scare people, especially the women. And so they'll try to use words like, oh, high capacity. No, it's not a high capacity magazine. It's a standard capacity magazine. And it's been in common use. The AR-15 is the single most commonly used firearm in the United States. No different than like a Honda or a Toyota being the most commonly driven car in the United States. Of course, the left's argument is going to be that, well, yeah, but they're used in the overwhelming majority of shootings. Well, yeah, that's because it's the most commonly used rifle. Just like Hondas and Toyotas are in more car accidents than any other car because there's more of them on the road. If you drive a Ferrari, there's only a couple of them, so there's less Ferrari accidents. So they frame and make these crazy arguments, and then they have these laws that they passed, like in Oregon, right, where they just basically outlawed math and reading to make it easier for people of color to graduate high school. But ultimately what that really is they just want to dumb people down, in my opinion, make them stupid, not teach them critical thinking for sure, because it's easier to control a population by giving them a welfare check and dumbing them down to where they have no clue that they're voting away their own rights in exchange for a paycheck from the government. Give me a bunch of ones if you agree. So that's pretty much all I had to say about that. What was that guy's name? The guy that said life is like a box of chocolates. That was a great movie. Anyways, and then CGL, right? So CGL makes a good statement that handguns are the most commonly used firearms in crimes, but what I was referencing is mass shootings. Like typically and when I say mass shooting, I just mean what PMS, NBC, and the CIA run news media calls a mass shooting, right? So it's usually going to be an AR-15 or the black rifle, right? The evil black rifle. And so, and VA disability. Well, Jason, I think VA disability is a little bit different. I think when you give someone a paycheck for nothing other than the fact that they vote for your political party is a lot different than a dude who put his life on the line, blew his ears out, blew his knees and back out to serve his country. So you guys can feel free to, all my mods can feel free to do what you want to do with that guy. Now, to ask such an absurd question, obviously this guy went to a public school, right? Now, assuming that he's being sarcastic. If not, strike that. But I'll let my mods make that decision. Now, what's the matter you? Fork v. Common. Stop playing stupid unconstitutional case law games. Well, unfortunately, the case law system has been in place since Sir William Blackstone, and prior to that, even in the other courts of the Pope, right? So we're kind of left with it. It's the only real way we have to be able to interpret decisions. But at the same token, I do agree with what's the matter you that it can be easily abused. And we see the way that the Ninth Circuit is using Heller and Miller and these other cases to stand for exactly what they don't stand for. So that's pretty scary to me as well. So, yeah, I mean, I feel for you, bro, because I understand what you're saying, but I also know that you've got to be able to have some kind of a system. Ultimately, what it boils down to is the education of the American people. If you were to homeschool and homestead and teach your children the true history of this country, the true history of despotism and totalitarianism, I don't believe that anybody would vote for people who would appoint judges that are doing these things that they are doing now. This is based upon a touchy-feely, scared of your own shadow mentality common in the government-run news media countries such as the United Kingdom, BBC, and here, unfortunately, we have the framework, the NPR, the very far-left, Marxist-run, in my opinion, NPR, that ultimately was going to become our version of the BBC. Give me a bunch of ones if you think that the NPR should be totally defunded from any tax money and that our government should never be involved in any kind of information that it gives to we the people, ever. They should never be funding it or providing money for any of it, because ultimately it becomes politicized and we the people suffer because our children believe authority figures. And they believe anything the press tells them, especially when they're very young and their school teachers tell them orange man bad, and that's all they hear. So another reason to homeschool as well. So anyways, things are good. Speak Life Garden, Lou Hazard. And Lou Hazard, I do agree to some degree with what you're saying, but if we had just left wing, there would be no Second Amendment right now. Mark my words, we would have 0 firearms. You probably would be arrested for having a pair of wire cutters, because that might be considered dangerous and unusual to one of these Marxist judges. So I do see that there is at least some give when it comes to our freedoms, at least to give it the appearance that we have some freedom. Give me a bunch of ones if you guys agree. But yeah, I'm doing good, man. NPR is not doing good at all, though, Beyond Watcher. It should be banned. It is so far Marxist left. It is so politicized. There's nothing that comes out of NPR that is impartial. And that's what journalists should be, is impartial, right? At least if they're going to be funded by your tax dollars, which NPR is. So in any event, I hope you guys enjoyed the show this morning. I had a decent little walk. Nothing like I used to, but I'm trying to stay somewhat in shape and be able to bring you stuff because I have a busy day today. I have hearings, getting ready for a trial. I want to make sure that I update you with the latest information. Catch me tonight. I'm supposed to be on Reluctant Prophet's channel talking about what's going on with Lane and his speedy trial issues and some other stuff. And with that being said, God bless you guys. Make sure to like and subscribe. Make sure to double tap that screen. Make sure to save, because we never know when the thought police are going to take down this channel.